Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, Washington, we're going to get the circle all the way back to our assault weapon ban now. Yeah, we've been geeking out on Illinois, been geeking out on Maryland's, been geeking out on California, and we're going to finally circle back to Washington's with the same type of news that we normally have when covering Washington's assault weapon ban, which of course is bad news. That's right. There was a challenge in the Eastern District of Washington, United States District Court for the Eastern District of Washington. They had a hearing a couple of weeks ago about an injunction. And well, have you seen my video telling you to run out there and grab yourself a new semi-automatic rifle? Of course you haven't. So I guess you know how it goes. But I want you to understand just how rotten this opinion truly is. So today, let's spend a few minutes, let's get you educated, and let's talk about another failed attempt to stop Washington's assault weapon ban. Hey man, what's going on?
What's up?
Dudes that are here to detail your car are here, they need the keys.
Oh.
All right, thanks man. All right guys, check it out. The keys to the McLaren are in here. Anyone gets into it, take it for a spin. Wait. What are you doing, man? No, that's not how this works. Okay, you guys give up?
I can't get it.
No clue. See you guys later. StopBox. Protect your family while protecting your family.
Where's my car?
Okay, Washington, the case we're talking about today is Bonta v. Ferguson. This is a case that challenges House Bill 1240, now codified into RCW 9.41, as our assault weapon ban, or what we like to call it, a ban of semi-automatic rifles and various other platforms of firearms. This was a case that was filed in the United States District Court for the Eastern District of Washington. There was oral arguments on whether or not the court should enjoin enforcement of this law, pending the outcome on the merits of this case. Hey, now, like I said earlier, did you see me doing this video going, woo, we got ourselves an injunction? No, I did not. And the reason is because we don't have an injunction. And we're not going to be getting one anytime soon. Now, one of the things we're going to learn about legal arguments today is that timing is everything. And the timing for this argument to roll around was not good at all. Because there are some pretty well-published opinions out there, but they come from like the 4th Circuit and the 7th Circuit and the 1st Circuit and the 9th Circuit. And none of those are particularly good. And the court, of course, hung its hat on this. This is, however, a very disingenuous ruling, and I want to go through it with you because I want you to understand what an uphill battle we truly have here in Washington State. Now, for those of you who geek out on this channel all the time, one, thank you very much. Number two, you know that in order to get injunctive relief, that is to get the court to put a big old pause button on the enforcement of a law, you need to show essentially two things. Number one, that you are likely to succeed on the merits of the argument, and number two, you are suffering from irreparable harm. The plaintiffs here never even made it out of the starting gates, okay? Because the court basically said, hey, listen, you have no real likelihood of succeeding on the merits. Why is that? Well, this is the disingenuous thing I want you to be aware of, because yes, this court has also ruled that the Second Amendment does not even cover this platform of firearms. Let me say that again. The semi-automatic rifle, the most common platform of long guns known to man today, is actually not protected by the Second Amendment, according to the United States District Court in the Eastern District of Washington. And trust me, the court looked for several ways to wiggle their way out of it. Consider this. There is no post-Bruin Ninth Circuit authority offering guidance on the Second Amendment's definition of arms or which arms do or do not fall under its protection. Really? Have we never read the Heller case? Have we never read the McDonald case? Have we never read any case that defines arms as anything that a person could take it in their hand and use to strike at another, either offensively or defensively? But apparently, the United States District Court for the Eastern District of Washington didn't get that memo. And then, of course, if you just go and cherry pick and you take a look at the crap that's come out of the Fourth Circuit, and you take a look at the crap that's come out of the Seventh Circuit, you take a look at the crap that routinely comes out of the Ninth Circuit, well, if you have the result of keeping civilian disarmament in place, you can find a conclusion like this. The majority of existing authority favors a Second Amendment test requiring plaintiffs to demonstrate that the weapons at issue are not only in common use for self-defense, but also tailored to that end, or that the weapons at issue are otherwise not too dangerous or unusual. I have no clue where that test came from. That is cherry picking from a bunch of cherry picked terrible opinions and yet creating a whole new rule of law out of thin air. And even though I think we could all agree what constitutes a bearable arm, yes, the United States District Court in the Eastern District of Washington, yeah, they struggle with that. The court disagrees that the current state of authority provides an obvious answer on what types of weapons are or are not included in the Second Amendment right. But you want to know what's even worse is the court is basically going to set up its own test and say, hey, listen, I don't really care about the numerical value. I don't really care about anything other than what I want to hear. And for the plaintiffs in this case, you have all failed to meet your burden that these are firearms which are in common use for lawful purposes, because that's what the test is, right? But instead, the court decides that moving forward, this will be the test now. The court will not deem a firearm in common use today for self-defense without a proffer of evidence explaining what the firearm is, how commonly Americans use it, and for what purpose it is used. Plaintiffs have failed to meet their burden to demonstrate that the bulk of the arms that SHB 1240 identifies are covered by the Second Amendment. Now, the court did acknowledge a lot of data that shows that these firearms are owned in the millions. And of course, if you take a look at how many are owned and then how many are used for crime, you can see that basically about 99.99999% of all of these firearms are used clearly only for lawful purposes. But hey, don't let the facts get in the way of a civilian disarmament piece of legislation, which of course then leads the court to conclude. In sum, the data presented suggests that AR-15s are commonly owned, and some who own them do so for self-defense. However, as explained above, most courts analyzing this issue have found commonality is not enough. In fact, most courts have considered whether the AR-15 falls under the Second Amendment's plain text, have concluded that it does not. And listen, anytime a court starts citing to the case of Beavis v. Naperville, if you're the plaintiffs, yeah, you know your goose is absolutely cooked. In Beavis, a consolidated appeal, the Seventh Circuit held that challengers to Illinois' assault weapon ban had failed to demonstrate a likelihood of success in showing that the AR-15 is protected by the Second Amendment. The court affirmed the district court's denials of a preliminary injunction, finding that the arms protected by the Second Amendment do not include weapons that may be reserved for military use. Yeah, well, you see, the AR-15 is not reserved for military use, neither by the United States Army nor any other military on the planet, because no military on the planet is actually using a semi-automatic long gun. But Washington, guess what? It gets even worse, because the court here says, hey, listen, even if the plain text of the Second Amendment covered this, there is ample historical analogs out there that justify the ban. And you sit there and go, I'm not familiar with any historical analogs that would be directly on point. You're right, there isn't any. But you see, this is where the Rahimi case comes back and haunts us, because as the court proudly put, but other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. When confronting such present-day firearm regulations, this historical inquiry that courts must conduct will often involve reasoning by analogy. But again, if you just want to play naive to what the case law says, you can just write this in your opinion. Similar to the above discussion of Bruin Step 1, there is little authority to guide the court's analysis at Bruin Step 2. Yeah, except for the Bruin case itself. I mean, I don't know what other authority you need. I think Bruin is written in pretty simple English. But again, if you take a look at all the intellectually dishonest opinions that have come out of the 4th Circuit, the 7th Circuit, some of the state Supreme Courts, the 9th Circuit, and you have civilian disarmament as the place that you want to land this opinion, well, then you can cherry pick these opinions and reach this conclusion. Therefore, even if the court were to continue to Bruin Step 2, it appears that the state defendants are likely to meet their burden under the currently available authority. And that, of course, is because under Rahimi, close is good enough. We used to say it was only good in horseshoes and hand grenades. I guess it's also close is good enough now in gun control legislation. So the case, once again, is Banta v. Ferguson. It will proceed now to argument on the merits. Let's not hold our breath on that after reading the opinion here as to the injunction. What does it mean to you, Washington? It means you're stuck in the same old crappy boat that we've been stuck in for a while now. However, we need to very carefully be watching the Snope case. That is Snope v. Brown. It is a petition for certiorari that is before the United States Supreme Court. This is a challenge to Maryland's assault weapon ban, almost verbatim identical to what we have here in Washington State. Okay, the case once again is Banta v. Ferguson. We're going to link it up down below so that you guys can take a look at the court's order. You might want to grab a barf bag before you start reading through it. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, go ahead and click on that link right there and let us know. It's probably going to be better than any idea we come up with. If you just want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.